Gentleman's time has expired. The gentleman from North Carolina, Mr. Coble.
Thank you, Mr. Chairman. Much has been made about the absence of bipartisanship on this issue, and I want to reiterate my position on that. Do not point accusatory fingers at Republicans or Democrats because there's disagreement. Assuming we vote our consciences and exercise sound judgment, little else can be asked. Some favor impeachment, some oppose it. The process then will move forward. I want to direct my attention to perjury, Mr. Chairman. I know of no situation, my friends, where sanctity is so generously laced as when one submits to an oath, then violates it. At this point, perjury rears its unsavory head. I represent a district far removed from the Beltway and its accompanying mentality. Here we are surrounded by Beltway advisors who demand fees in excess of $500 per hour. And many of these adept advisors, lawyers, counselors, or spinmeisters, they attach their spin, and oftentimes confusion results. But when I return to my district, I sometimes motor south on Highway 29 through the fox and the wine country of Virginia. And as I approach the North Carolina boundary line, my mind begins to clear, as I am at that point removed from the Beltway spin. All of a sudden, I am aware of the definition of sex. All of a sudden, I know the meaning of alone. I know what is, as do the majority of my constituents. Many have compared the present White House crisis to Watergate. There are similarities, there are distinctions. One glaring similarity, in my opinion, my friends, is this. If President Clinton and President Nixon had come before the American people in a timely way, and by that, Mr. Chairman, I mean early in the game, and sincerely apologized for their offenses or crimes, we likely would not be here today. Watergate misconduct, as well as current White House misconduct, are, in my opinion, subject to impeachment. But the American people are a forgiving people. But neither President Nixon nor President Clinton saw fit to pursue the course I have just outlined. Oliver Wendell Holmes said, "Sin has many tools, but the lie is the handle that fits them all." And the centerpiece to this scenario, I am convinced, ladies and gentlemen, is not sex. It is indeed perjury. It is the lie. It's the handle to the tool. And as best I can determine, there are no exceptions to the perjury statutes. And if we turn a blind eye to perjury in this instance, what precedent do we establish when subsequent cases involving perjury must be resolved fairly and impartially? Finally, I take umbrage to charges that some are out to get the president. Mrs. Bono, the gentlewoman from California, earlier said this week that it is not we on this committee who created the problem that's now before us. That's what was the president's doing. I take umbrage as well to those who claim that some approach this arduous task in a gleeful manner. I take no joy in discharging this duty before us, but it remains our duty nonetheless. Mr. Chairman, every 25 years, it seems, the House Committee on the Judiciary charts its course through impeachment waters. We spend the remaining years in relative obscurity compared to some of our House committees that enjoy higher levels of profile than we. And I must confess, and I may be speaking for all the members on the Judiciary Committee, I must confess, I long for the days of relative obscurity. That may come one of these first days. My good friend from Michigan, the distinguished ranking member, referred to the shutdown of the government when he said the Congress shut down the government. Let me talk a minute about that. When the government shut down in 1991, President Bush was blamed for the shutdown. When the government shut down in 1995, the Congress was blamed for the shutdown. Still hadn't figured that one out. I think the truth of the matter is President Bush and the Congress closed down the government in 91. President Clinton and the Congress closed down the government in 95 for under very almost identical circumstances. They were the inability to agree on spending measures. So I don't believe that assuming impeachment will follow, I don't think that will accelerate the shutting down of the government. My good friend from New York talked about, oh, it's going to tie everything up. And it may well tie up to some extent, but I'm the eternal optimist. I forever see that glass half filled, and I can't see that this is going to shut down the government or tie it up, assuming it does advance to the Senate. Having said all that, Mr. Chairman, I am happy to report the red light has not illuminated, and I yield back my time.
I thank the gentleman from North Carolina and the gentleman from California, Mr. Berman.
Well, thank you, Mr. Chairman. Chairman Hyde, wherever you are, I often disagree with you, but I've always known you to be a fine and decent man, and you've often been unfairly attacked throughout this process, and I, for one, want to commend you for the way you have handled these proceedings. And I also want to express to my friend, Mr. Conyers, wherever he is, my appreciation for his effective and wise leadership as my ranking minority member. The often repeated mantra that everybody lies, certainly everybody lies about sex, all presidents lie, and many presidents have affairs, must be addressed from this side of the table. It's certainly true that people sometimes lie, and that people often lie about sex. And it is also true that presidents have been known to lie, and that some presidents have had affairs. But that mantra has nothing to do with the issues before us. That mantra does not address the allegations of lying under oath or coaching potential witnesses in legal proceedings in order to evade responsibility for personal wrongdoing. Our proceedings are too momentous to be bogged down by this political spin. What is an impeachable offense? A precise definition is difficult to glean from the framers of the Constitution, American history, or scholarship. I find the best answer, albeit on a different subject, contained in the concurring opinion of Supreme Court Justice Potter Stewart, from which I quote, "The court was faced with the task of trying to define what may be indefinable. I shall not today attempt further to define the kinds of material I understand to be embraced, and perhaps I could never succeed in intelligibly doing so. But I know it when I see it." Justice Stewart was ruling on the definition of obscenity, not impeachment, and given his subject matter, some may think this analogy too apt. But as regards the basic concept of what constitutes an impeachable offense, for me the logic applies. I know it when I see it. And on balance, given the totality of the wrongdoing and the totality of the context, this isn't it. In fact, though reasonable people may disagree, I don't think it's a close call. The president's behavior that reflects so badly on the presidency and the country, the president's disregard for his obligations as a law-abiding American, the president's refusal to respect a common-sense interpretation of the English language, this conduct does not rise to the level that justifies thwarting the public's mandate as expressed in the 1996 election. My vote to oppose impeachment turns on three factors. The first factor is, though this is not just about sex, it is colored by sex. Second, and more importantly, impeachment must not be pursued if the center of gravity of the body politic opposes impeachment. We are privileged to live in a unique and wonderful system. Every 4 years, we come together to elect a president. This is the defining moment in American political life and is portentous in its implications. Each American takes responsibility, and as a whole, all America takes collective responsibility for the decision to invest awesome power in this one person. There must have been a reason why the framers vested this power of impeachment in a political body, the People's House, the House of Representatives. If they had wanted impeachment to be a non-political decision, totally divorced from public opinion, they would have vested impeachment powers in the judicial branch. The impeachment process must, at a minimum, pay some deference to the totality of the people's views. Unlike every other vote we cast, where conscience may play a determinative role, regardless of public opinion, a vote for impeachment cannot be blind to the views of those who vested power in the president. It would be very, very wrong to expunge the results of an election for the President of the United States without the overwhelming consent of the governed. It should not be contemplated unless the wrongdoing is so egregious as to threaten our form of government. The third factor in my decision is the belief that the corrosive effects on American society and Americans' legal system of allowing the president to serve out his term have been overstated. It is true that the president's defense is very troubling. His grand jury testimony, his public statements following the grand jury testimony, his agents' public statements, his answers to the questions submitted to the committee are more serious than any wrongdoing that caused this process to begin. There is something Alice in Wonderland-like. Watching someone so smart and so skilled, so admired by the American people for his intellect and his talents, digging himself deeper and deeper and deeper into a rabbit hole, and us along with him, and allowing him to escape accountability. This troubles me greatly, and I know it motivates many of the calls for impeachment. People do have a right to ask, what will America's children believe about lying, about reverence for the law, about lying under oath? Will more Americans think it is okay to lie under oath if the subject matter is sex, or if the subject matter is embarrassing, or to evade civil liability in a sexual harassment suit, or to evade criminal liability? Many thoughtful Americans wonder whether the deconstruction of our language, the hair splitting, will damage the culture even beyond the legal system. What will happen if words no longer have common sense meaning? If everything is equally true or not true? Because, after all, it depends on what your definition of is. Of course there has been and will be harm to our culture in the legal system, but let's keep it in perspective. This is not a court of law. We're not empowered to decide whether or not the president should be indicted or convicted of a criminal offense. While not above the law, the president, the most powerful man on the planet, the man who has control over our nuclear weapons arsenal, the man whom we vest with the authority to protect and defend the interests of the people of the United States, indeed protect all civilization, is a special case. Everybody is equal under the law, but we make special provisions for one person while he's serving as president. Few would dispute the fact that the president is immune from criminal prosecution during his term of office. Many would argue, I certainly would, that a wise Congress should pass legislation to immunize the president from civil litigation during his term of office. We invest the Secret Service with the responsibility of taking the bullet so our commander-in-chief will serve out his term. Most Americans will be criminally prosecuted at any time. Most Americans can be civilly sued at any time. Most Americans do not have a cadre of heroes providing personal protection for them and their loved ones. That the president's conduct is not impeachable does not mean that society condones his conduct. In fact, it does not mean that the president is not subject to criminal prosecution after he leaves office. It just means that the popular vote of the people should not be abrogated for this conduct, when the people clearly do not wish for his conduct to cause that abrogation. The point is, most Americans know, and will instruct their children to know, that conduct that may not be impeachable for the President of the United States is not necessarily conduct that is acceptable in the larger society. Those who argue that the institutions of government or the fabric of our society will be irreparably harmed by a failure to impeach the president seriously underestimate the American people. America is too strong a society. American parents are too wise. The American sense of right and wrong too embedded to be confused. We all know that the word is has a common sense meaning. We all know that lying under oath will get us in a lot of trouble. I have anguished over the question, were the facts the same for a Republican president and a democratically controlled Congress, would I vote the same way, oppose impeachment? I pray that my decision would be the same, regardless of party, regardless of political position. I hope I've considered only what meets the constitutional standard and what is best for America. I find the answer unambiguous. Impeachment must be defeated.
Gentleman's time has expired. The gentleman from Texas, Mr. Smith.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. First, I want to acknowledge the thoughtful statement made by the gentleman from California who just spoke.
The gentleman change his vote.
Mr. Chairman, our Constitution tells us the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. To impeach, which lies only within the power of the House, means to accuse or charge with a crime. Only the Senate can actually convict and remove from office. As a distinguished Democratic member of the Judiciary Committee said during the Nixon impeachment proceeding, it is wrong, I suggest. It is a misreading of the Constitution for any member here to assert that for a member to vote for an article of impeachment means that that member must be convinced that the president should be removed from office. The Constitution doesn't say that. The powers relating to impeachment are an essential check in the hands of this body, the legislature, against and upon the encroachment of the executive. In establishing the division between the two branches of the legislature, the House and the Senate, assigning to the one the right to accuse and to the other the right to judge, the framers of this Constitution were very astute. They did not make the accusers and the judges the same person, end quote. After consideration of all the evidence presented, I am convinced it is sufficient for the House to charge the President with several wrongful actions. I feel the evidence shows that the President committed perjury by lying under oath, obstructed justice, and abused the power of his office. Both historical precedent and current practice support the conclusion that perjury is a high crime and misdemeanor. The Constitution applies that same phrase both to the President and to all civil officers of the United States. Several federal judges have been impeached and removed from office for perjury. That is why the President can be too. Also, bribery and perjury are equivalent means of interfering with the justice system. The federal sentencing guidelines include bribery and perjury in the same guideline. Some of the President's defenders would like to change the subject and talk about anybody else but the President and about anything else except the allegations of lying under oath, obstruction of justice, and abuse of office. Such efforts are an affront to all who value truth over tactics, substance over spin, principles over politics. Judiciary Committee members will be consistent if they follow the precedent established in 1974. Individuals from both parties agreed with a Democratic Congresswoman from Texas when she said, "The President engaged in a series of public statements and actions designed to thwart the lawful investigation by government prosecutors. Moreover, the President has made public announcements and assertions which the evidence will show he knew to be false. These assertions, false assertions," she said, "are impeachable. By any common sense measure, the President did not tell the truth, the whole truth, and nothing but the truth as his oath required when he testified before a judge and then before a grand jury, as several Democrats on this committee now admit. We should not underestimate the gravity of the case against the President. When he put his hand on the Bible and recited his oath of office, he swore to faithfully uphold the laws of the United States, not some laws, all laws. As committee witnesses have testified, many people have gone to jail for doing what the president did, lying or knowingly making false statements after swearing in court not to do so. However, others have not been punished for failing to tell the truth. So, if the president were just an ordinary person living in the United States, it is not certain that he would be found to have committed a crime. What then makes this a case that rises to the impeachment level? I think there are two factors: the repeated and deliberate nature of the lies and the uniqueness of the office of the presidency. It was determined by the independent counsel that, quote, on at least 6 different occasions from December 17, 1997 through August 17, 1998, the president had to make a decision. He could choose truth or he could choose deception. On all 6 occasions, the president chose deception, a pattern of calculated behavior over a span of months. During this time, not only did the president tell a judge and then a grand jury less than the truth, he also told lies to the American people, the news media, members of Congress, his cabinet, and senior White House advisors. One of his own former advisors commented, President Clinton turned his personal flaws into a public matter when he made the whole country complicit in his cover story. This was no impulsive act of passion. It was a coldly calculated political decision. He spoke publicly from the Roosevelt Room. He assembled his cabinet and staff and assured them that he was telling the truth. Then he sat back silently and watched his official spokespeople, employees of the U.S. government, mislead the country again and again and again, end quote. The president himself, when he was a law professor in Arkansas, defined an impeachable offense this way. I think that the definition should include any criminal acts plus a willful failure of the president to fulfill his duty to uphold and execute the laws of the United States. Another factor that I think constitutes an impeachable offense would be willful, reckless behavior in office. The president consciously and persistently made an effort to deceive, give misleading answers, and tell lies. He made statements and engaged in actions designed to impede the investigation of the independent counsel. We all know the president still might be deceiving us today were it not for physical evidence that forced him to change his story. As to the uniqueness of the office the president holds, he is a person in a position of immense authority and influence. He influences the lives of millions of Americans. He sets an example for us all. A 6th grader from Chisholm Middle School in Round Rock, Texas, recently wrote me. She said bluntly, he has lied to the American people. And although I realize what he lied about has nothing to do with him running the country, then what else would he lie about? He let us down. Kids that think he is a role model now are heartbroken. The president sets an example for adults too. When he took the oath of office, he swore to preserve, protect, and defend the Constitution of the United States, and to take care that the laws be faithfully executed. The president has rightly been called the #1 law enforcement officer of the country. As such, he has a special responsibility to take care that he not commit any crime, particularly such a serious one as perjury, a felony for which a person can go to jail for up to 5 years. When someone is elected president, they receive the greatest gift possible from the American people, their trust. To violate that trust is to raise questions about fitness for office. My constituents often remind me that if anyone else in a position of authority, for example, a business executive, a military officer, or professional educator, had acted as the evidence indicates the president did, their career would be over. The rules under which President Nixon would have been tried for impeachment had he not resigned contain this statement. The office of the president is such that it calls for a higher level of conduct than the average citizen in the United States. The president has a higher responsibility for another reason. The Arkansas Rules of Conduct for Attorneys state that lawyers holding public office assume legal responsibilities going beyond that of other citizens because they know how important the rule of law is to a stable and civilized society. And the president doesn't hold just any public office. He holds the most powerful one in the world. For these two reasons, the president's premeditated and repeated efforts while under oath to tell less than the truth, and the special responsibility that comes with holding the highest office in our country, that I feel the president's actions have reached the level of impeachable offenses. I have been surprised by the assertion of the president's defenders that we should not impeach him for his actions because it would set a precedent. Mr. Chairman, I notice that I'm out of time, but I've never asked for unanimous consent for additional time before, and if I could, I'd like to have another minute, perhaps to offset the compliment I issued to the gentleman from California.
Well, reluctantly, without objection, the gentleman is given another minute.
Thank you, Mr. Chairman. If our actions send a message that future presidents should not lie under oath, should tell the truth, the whole truth, and nothing but the truth, as President Clinton swore to do when giving testimony before a judge and then a grand jury, that future presidents should uphold the law as President Clinton swore to do when he took the oath of office as president, that future presidents should not obstruct justice, as President Clinton did for 7 months as he admittedly deceived the American people and those associated with the investigation. If these are the precedents Congress sets, if these are the standards future presidents then live by, we need not fear our actions. This will not be an easy task. In fact, it is a difficult ordeal for all Americans, but we will get through it. We are a great nation and a strong people. Our country will endure because our Constitution works and has worked for over 200 years. As much as one might wish to avoid this process, we must resist the temptation to close our eyes and pass by. The president's actions must be evaluated for one simple reason: the truth counts. As the process goes forward, some good lessons can be reaffirmed. No one is above the law. Actions have consequences. Always tell the truth. We, the people, should insist on these high ideals. That the president has fallen short of the standard doesn't mean we should lower it. If we keep excusing away the president's actions,
Gentleman's time is
we
again
as a nation will never climb upwards because there will be no firm rungs.
Mr. Chairman, I ask unanimous consent to allow the gentleman to complete his statement.
without objection.
I'm almost finished, and I appreciate the indulgence of my colleagues. Let me quote another insightful letter from a student in that same sixth grade class. As everyone knows, it begins, President Clinton is going through hearings about lying under oath and tampering with the evidence. Perjury, especially in front of a grand jury, is unacceptable. These many months of investigation could have been avoided if President Clinton would have told the truth in the beginning. She concludes her letter with words I will use to conclude my remarks. Quote, I know you are being bombarded with letters, each with different opinions, but this is a big issue. Now it is up to you and your fellow congressmen to decide to the best of your ability what should happen next. Please take into consideration what I have stated and make a decision that would be the best for America's future. That, my colleagues, to me, says it all, and I yield back the balance of my time.
The gentleman's time has long since expired. The chair would ask the members to please try to time their statements to fit as closely to the 10 minutes that were announced by the chair and agreed to by unanimous consent as possible. The gentleman from Virginia, Mr. Boucher.
Thank you very much, Mr. Chairman. I would like to join with others who have expressed similar remarks in expressing my appreciation to Chairman Hyde and also to the ranking Democrat on this committee, John Conyers, for the leadership that they both have provided during what has been at oftentimes a difficult process. I think they have both performed well, and I want to thank them for it. I have reviewed carefully the information that has been presented to this committee by the independent counsel and by other witnesses who have testified before the committee, and I have concluded that a congressional response is required to the actions of the president. The president made false statements concerning his reprehensible conduct with a subordinate. He wrongfully took steps to delay discovery of the truth. He has diminished his personal dignity and that of the office of the presidency. He has brought the presidency into disrepute and impaired the image of the president as a role model for younger Americans. The question we must now decide is whether to adopt a resolution censuring and rebuking the president for these actions, or whether we should adopt articles of impeachment directed toward his removal from office. In deciding which of these alternatives is more appropriate, I have carefully reviewed the historical precedents for the use of both in light of the facts which have been presented to this committee, and I have concluded that a statement by the Congress formally censuring and rebuking the president for his conduct is more appropriate in these circumstances. Of particular value to me in this analysis was the most recent congressional pronouncement on the proper use of the impeachment power. It is found in the report issued on a broad bipartisan basis by this committee in its 1974 proceeding in the Watergate inquiry. That report concludes that the framers of the Constitution vested the impeachment power in the House of Representatives with the intent that it only be used to advance the national interest. It was designed to remove from office a chief executive whose conduct threatens the nation. Not all presidential misconduct, whether criminal or non-criminal, justifies impeachment. To quote this committee's report, only that misconduct which is seriously incompatible with either the constitutional form and principles of our government or the proper performance of the duties of the presidential office will justify a use of the impeachment power. This is the standard that we should apply today. It was applied by our predecessors on this committee in 1974. It gives further definition to our common understanding that overturning a national election and removing a president from office is a drastic remedy to be used only when the survival of our constitutional form of government is at stake. The facts now before this committee, which arise from a personal relationship and the effort to conceal it, simply do not arise to that standard. While the president's conduct was reprehensible, it did not threaten the nation. It did not undermine the constitutional form and principles of our government, and it did not disable the proper performance of the constitutional duties of the presidential office. It does not rise to the standard for impeachment set by our predecessors in 1974. It is equally clear that impeachment was never intended as a punishment for misconduct by the chief executive. The Constitution in Article 1, Section 3 specifically provides that the president can be tried in the criminal courts after he leaves office for any crimes that are committed during his presidential tenure. Since the president is clearly subject to the criminal justice process, the rule of law will be upheld, and the principle that no person, including the president, is above the law will be honored. This president, I should note, is also subject to sanctions being imposed by the federal judge in Arkansas who presided in the civil lawsuit in which he gave the deposition that has been so much a subject of discussion in these proceedings. Impeachment should not be employed as the punishment for the president. That punishment can come through the criminal courts or through the sanctions imposed by the federal judge in Arkansas. Also weighing against the use of the impeachment power is the virtual certainty that the Senate would not convict the president and remove him from office if the House of Representatives votes favorably on articles of impeachment. A vote of 2/3 of the Senate would be required for that action, and it is universally acknowledged that a 2/3 vote in the Senate to convict the president and remove him from office cannot be obtained. Therefore, for the House of Representatives to approve articles of impeachment would simply prolong this national debate for many more months without bringing closure, further polarizing the country and hardening the divisions that exist in our population at the present time, diverting the Congress and the President from attending to our urgent national business, immobilizing the Supreme Court while the Chief Justice presides over a prolonged trial in the Senate, lowering the standard for future presidential impeachments, and possibly causing disruptions in the financial markets to the detriment of our national economy. For all of these reasons, I'm convinced that impeachment is not the appropriate remedy in this case. Its use would not well serve the national interest. I share the public's deep disdain for the actions of the President, and I'm truly concerned that if Congress takes no action, many troubling unanswered questions will remain with regard to the example that his conduct sets. A resolution of censure passed by both houses of Congress requiring the signature of the President as an acknowledgement of the public's rebuke of his tawdry conduct is the preferable alternative. Tomorrow, I will offer with colleagues of like mind such a resolution of censure for consideration by this committee. Our congressional censure of the President for his conduct, combined with his susceptibility to the criminal justice process and to possible sanctions by the federal court in Arkansas, will constitute an appropriate admonishment for his conduct, which we all disdain. It is my hope that in the days ahead, a consensus can be achieved which leads to this sensible conclusion, if not in this committee, then on the floor of the U.S. House of Representatives, which more than any other approach will simultaneously acknowledge our long constitutional history and place the nation, the Congress, and the presidency on a path toward the restoration of dignity. Thank you, Mr. Chairman. I yield the balance of my time.
That's appreciated. The gentleman from California, Mr. Gallagher.
Thank you very much, Mr. Chairman. Mr. Chairman, we've been waiting for months for President Clinton or his representatives to offer facts that negate the charges in Judge Starr's referral to this committee. During those long months, I made a commitment to refrain from judging the President's guilt or innocence until we had the facts. This has been a very trying time. In a democracy, there are few more serious acts than to consider the possible impeachment of a president. I can tell you in true conscience it has caused me many sleepless nights. The charges Judge Starr presented against President Clinton were strong, but they were only charges. I wanted to hear the evidence that would prove the charges were false. I believe that was the only fair way to proceed, and it was also my solemn constitutional duty and immense responsibility. I waited, I read, and I listened. Finally, last week, President Clinton announced he would launch a vigorous defense. On Tuesday morning, Mr. Craig, the President's counsel, said he would present a powerful case based on the facts already in the record and on the law. A powerful case against the impeachment of our President. What I heard, unfortunately, was more legal hair splitting. Even some of the President's witnesses said President Clinton had lied. Only presidential attorney, Mr. Ruff, mounted a vigorous defense of the facts and the record, but I found his conclusions flawed. I have carefully weighed the evidence, Mr. Chairman. I can only conclude that the President repeatedly lied under oath. His lies under oath, I believe, were intentional and premeditated. First, in December of 1997, the President lied under oath in his written answers to a federal court. Second, in January, the President lied under oath repeatedly in the Jones deposition. Third, he willfully and knowingly influenced witnesses and obstructed justice in Ms. Jones' pending lawsuit. He lied to the American people. He lied to Congress, his staff, his cabinet, his party leaders, all to protect himself and frustrate justice. Fourth, in August, the President lied under oath before a federal grand jury. The President lied to the American people when he addressed us after that appearance. Finally, only days ago, the President lied under oath again when he answered the 81 questions posed to him by this committee. The President had many opportunities to come clean and tell the truth. Instead, he continued to lie under oath. He lied under oath despite bipartisan pleas to testify truthfully. It has been argued that we should not impeach President Clinton because we should not hobble future presidents with the possibility they could be impeached for the same thing. Mr. Lowell, the Democrat counsel this morning, stated We should not impeach to punish, but rather to preserve the public trust. Future presidents should fear impeachment for lying under oath. Impeaching a president for lying under oath would do what Mr. Lowell suggests: protect the public trust. Instead of acting presidential and putting the country before his own self-interest, President Clinton chose his own self-interest time and time again. By doing so, he undermined the rule of law and violated his oath of office. The president, his delegates, and my Democrat colleagues argue that even these facts are provable. They do not rise to the level of impeachment. With all due respect, I believe they're wrong. Lying after swearing before God and country to tell the truth, the whole truth, and nothing but the truth is a very serious offense. It is taken very seriously by our judicial system, one of the three equal branches of government in the United States. In this case, President Clinton lies under oath before a federal judge, a grand jury, or a direct attack on the constitutional separations of power. On a more basic level, he lies under oath, directly attacks the rule of law. This is about a president of the United States lying under oath, undermining our legal process, and violating his oath of office. It is about violating Article 2, Section 3 of the Constitution, which states the president shall take care that the laws be faithfully executed. President Clinton's actions clearly fall under the heading of high crimes and misdemeanors. Our legal system, which protects the rights and liberties of all citizens, is dependent on people telling the truth under oath. The president is our chief law enforcement officer and our chief magistrate. When he lies under oath, he undermines the integrity of our judicial system and threatens the rights and liberties of every one of us. Mr. Chairman, I'm not a lawyer, one of the few on this committee. However, everyone that knows me knows I believe in the rule of law. Believe in the rule of law is fundamental to our society. A society without laws is anarchy. Societies that ignore the laws are condemned to violence and chaos. The president's actions have already impacted children in my district. An educator at one of the Moore Park Junior High schools called me this week. She said that in the last few months, students have lied about bad conduct and try to excuse themselves with a comment, well, the president did it, why can't I? That bothers me. My district is considered among the safest communities in the nation. We have fine police officers, which certainly helps. But every officer from the chief to the beat officer will tell you a low crime rate begins with citizens who obey the law. Every citizen must obey the law. Every law. No citizen has the right to pick and choose what laws he or she may follow just because it may be embarrassing or inconvenient. Our course is certain. Before us is clear evidence that the president willfully and knowingly lied under oath, repeatedly and consistently. Those lies under oath are an attack on the rule of law against the very fabric of our society. He violated his oath of office and willfully sought to deny justice to another citizen. He violated the Constitution. To condone this would be to condemn our society to anarchy. Mr. Chairman, I cannot and will not condone such action. I yield back.
Gentleman's time has expired. The gentleman from New York, Mr. Nadler.
Thank you, Mr. Chairman. Mr. Chairman, today, for only the third time in our nation's history, this committee meets to consider articles of impeachment against the President of the United States. This is a momentous occasion, and I would hope that despite the sharp partisan tone which has marked this debate, we can approach it with a sober sense of the historic importance of this matter. I believe we need to get back to basics, the Constitution, and what the impeachment power conferred on the Congress requires of us. Article 2, Section 4 of the Constitution says that a president, quote, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors, end quote. We have received testimony from some of the nation's leading scholars and historians who agree that impeachable offenses are those which are abuses of presidential power that undermine the structure or functioning of government or constitutional liberty. Benjamin Franklin called impeachment a substitute for assassination. It is, in fact, a peaceful procedure for protecting the nation from despots by providing a constitutional means for removing a president who would misuse his presidential power to make himself a tyrant or otherwise to undermine our constitutional form of government. To impeach a president, it must be that serious. The history of the language is also clear. At the Constitutional Convention, the Committee on Style, which was not authorized to make any substantive changes, dropped the words "against the United States" after the words "high crimes and misdemeanors," because it was understood that only high crimes and misdemeanors against the system of government would be impeachable, that the words "against the United States" were redundant and unnecessary. History and the precedents alike show that impeachment is not a punishment for crimes, but a means to protect our constitutional system, and was certainly not meant to be a means to punish a president for personal wrongdoing not related to his office. Some of our Republican colleagues have made much of the fact that some of the Democrats on this committee in 1974 voted in favor of an article of impeachment relating to President Nixon's alleged perjury on his tax returns. But the plain fact is that a bipartisan vote of that committee, something we have not yet had in this process on any substantive question, rejected that article. That's the historical record, and it was rejected largely based on the belief that an impeachable offense must be an abuse of presidential power, a great and serious offense against the nation, not perjury on a private matter. I have heard it said tonight that perjury is as serious an offense as bribery, that it is equivalent to bribery, a per se impeachable offense. But bribery goes to the heart of the president's conduct of his constitutional duties. It converts his loyalties and efforts from promoting the welfare of the republic to promoting some other interest. Perjury is a serious crime, and if proven, should be prosecuted in a court of law. But it may or may not implicate the president's duties and performance in office. Perjury on a private matter, perjury regarding sex, is not a great and serious offense against the nation. It is not an abuse of uniquely presidential power. It does not threaten our form of government. The effect of impeachment is to overturn the popular will of the voters as expressed in a national election. We must not overturn an election and remove a president from office except to defend our very system of government or our constitutional liberties against a dire threat. And we must not do so without an overwhelming consensus of the American people and of their representatives in Congress of the absolute necessity. There must never be a narrowly voted impeachment or an impeachment substantially supported by one of our major political parties and largely opposed by the other. Such an impeachment would lack legitimacy, would produce divisiveness and bitterness in our politics for years to come, and will call into question the very legitimacy of our political institutions. The American people have heard all the allegations against the president, and they overwhelmingly oppose impeaching him. The people elected the president. They still support him. We have no right to overturn the considered judgment of the American people. There are clearly some members of the Republican majority who have never accepted the results of the 1992 or 1996 elections and who apparently have chosen to ignore the message of last month's election. But in a democracy, it is the people who rule, not political elites, and certainly not those members of political elites who will not be here in the next election and the next Congress having been repudiated at the polls. Some members of this committee may think the people have chosen badly, but it is the people's choice, and we must respect it absent a fundamental threat to our democratic form of government that would justify overturning the repeated expression of the people's will at the ballot box. Members of Congress have no power, indeed they have no right, to arrogate to themselves the power to nullify an election absent such a compelling threat. We have also received testimony from some outstanding former prosecutors, including the former Republican governor of Massachusetts, Bill Weld, who headed up the criminal division of Ronald Reagan's Justice Department, who compellingly explained why all the loose talk about perjury and obstruction of justice would not hold up in a real prosecutor's office, that the evidence we have been given would never support a criminal prosecution in a real court of law. For those who demand that the president prove his innocence, rather than his accusers having to prove his guilt, or even to state clearly the specific charges, we received answers from Mr. Ruff yesterday and from Mr. Lowell this morning, in which they meticulously pointed out, using Mr. Starr's own work, how the charges were not supported and were indeed contradicted by the evidence of Mr. Starr's own office had assembled. In fact, Mr. Starr has stated in his referral to Congress that his own star witness is not credible, except when her uncorroborated testimony conflicts with the president's, and then it proves his perjury. We have received sanctimonious lectures from the other side of the aisle about the rule of law, but the law does not permit perjury to be proved by the uncorroborated testimony of one witness. Nor does the law recognize as corroboration the fact that the witness made the same statement to several different people. You may choose to believe that the president was disingenuous, that he was not particularly helpful to Paula Jones's lawyers when they asked him intentionally vague questions, or that he is a bum. But that does not make him guilty of perjury. This committee, this House, is not a grand jury. To impeach the president would subject the country to the trauma of a trial in the Senate. It would paralyze the government for many months, while the problems of Social Security, Medicare, a deteriorating world economy, and all our foreign concerns festered without proper attention. We cannot simply punt our duty to judge the facts to the Senate if we find mere probable cause that an impeachable offense may have been committed. To do so would be a derogation of our constitutional duty. The proponents of impeachment have provided no direct evidence of impeachable offenses. They rely solely on the findings of a so-called independent counsel who has repeatedly mischaracterized evidence, failed to include in his report exculpatory evidence, and consistently misstated the law. We must not be a rubber stamp for Kenneth Starr. We have been entrusted with the grave and awesome duty by the American people, by the Constitution, and by history. We must exercise that duty responsibly. At a bare minimum, that means the president's accusers must go beyond hearsay and innuendo and beyond demands that the president prove his innocence of vague and changing charges. They must provide clear and convincing evidence of specific impeachable conduct. This they have failed to do. If you believe the president's admission to the grand jury and to the nation of an inappropriate sexual relationship with Ms. Lewinsky and his apologies to the nation were not abject enough, that is not a reason for impeachment. Contrition is a remedy for sin and is certainly appropriate here. But while insufficiency of contrition may leave the soul still scarred, unexpiated sin proves no crimes and justifies no impeachments. Some say that if we do not impeach the president, we treat him as if he is above the law. Is the president above the law? Certainly not. He is subject to the criminal law, to indictment and prosecution when he leaves office like any other citizen, whether or not he is impeached. May I ask one additional minute?
Without objection.
Thank you. And if the Republican leadership allows a vote, he would likely be the third president in U.S. history and the first since 1848 to be censured by the Congress. But impeachment is intended as a remedy to protect the nation, not as a punishment for an errant president. The case is not there. The proof has not been put forward. The conduct alleged, even if proven, does not rise to the level of an impeachable offense. We should not dignify these articles of impeachment by sending them to the full House. To do so would be an affront to the Constitution and would consign this committee to the condemnation of history for generations to come. Thank you, Mr. Chairman.
Gentleman's time has expired. The gentleman from Florida, Mr. Kennedy.
Thank you, Mr. Chairman. I want to begin by thanking Mr. Hyde for his outstanding leadership of this committee during these difficult days. In the face of a determined effort to undermine and discredit the work of the committee, Mr. Hyde has conducted these proceedings with his accustomed dignity, grace, and honor. And for that, I express to Mr. Hyde my gratitude and my respect. Many have asked why we are even here in these impeachment proceedings. They have asked why we can't just rebuke the president and move on. That's a reasonable question, and I certainly understand the emotions behind that question. I want to move on. Every member of this committee wants to move on. We all agree with that. But the critical question is this: do we move on under the Constitution, or do we move on by turning aside from the Constitution? Do we move on in faithfulness to our own oath to support and defend the Constitution, or do we go outside the Constitution because it seems more convenient and expedient? Why are we here? We are not here to deal with the sins of the President. That's a matter between the President and his family and God. Unfortunately, however, the President's sins led him to commit crimes. His sins led him to engage in a calculated and sustained pattern of lying under oath and obstructing the due administration of justice. And that indeed is the proper subject of our inquiry. Why are we here? We are here because we have a system of government based on the rule of law, a system of government in which no one is above the law. We are here because we have a Constitution. A Constitution is often a most inconvenient thing. A Constitution limits us when we would not be limited. It compels us to act when we would not act. But our Constitution, as all of us in this room acknowledge, is the heart and soul of the American experiment. It is the glory of the political world. And we are here today because the Constitution requires that we be here. We are here because the Constitution grants the House of Representatives the sole power of impeachment. We are here because the impeachment power is the sole constitutional means granted to Congress to deal with the misconduct of the Chief Executive of the United States. In many other countries, a matter such as this involving the head of government would have been quietly swept under the rug. There would, of course, be some advantages to that approach. We would all be spared embarrassment, indignity, and discomfort. But there would be a high cost if we followed that course of action. Something would be lost. Respect for the law would be subverted, and the foundation of our Constitution would be eroded. The impeachment power is designed to deal with exactly such threats to our system of government. Conduct which undermines the integrity of the President's office, conduct by the Chief Executive which sets a pernicious example of lawlessness and corruption, is exactly the sort of conduct that should subject a president to the impeachment power. Alexander Hamilton himself acknowledged that those who set examples which undermine or subvert the authority of the laws lead us from freedom to slavery. That is what William Jefferson Clinton has done. There must be a constitutional remedy. The first Chief Justice of the United States, John Jay, said that no crime is more extensively pernicious to society than perjury. That is the crime that William Jefferson Clinton has committed repeatedly in a calculated effort to thwart justice. There must be a constitutional remedy. There is a constitutional remedy for such high crimes and misdemeanors. The constitutional remedy is impeachment. I freely acknowledge that reasonable people can disagree about the weight of the evidence on certain of the charges. For example, I think there is doubt about the allegations that the President willfully lied concerning the date his relationship with Ms. Lewinsky began. But when we set aside any doubtful matters, we are still left with compelling evidence that the President made multiple false statements under oath, both in a civil rights case and before a federal grand jury, that he engaged in other conduct to corruptly influence the administration of justice, and that he lied in sworn statements submitted to this very committee. He did this not simply to avoid personal embarrassment. Of course, that was one of his objectives. But on the contrary, he lied under oath and obstructed justice in a calculated effort to defeat the rights of a plaintiff in a federal civil rights case. Having done that, he went on to lie before a grand jury to cover up and avoid responsibility for his earlier crimes. Then he compounded his offense by submitting false statements under oath to this committee. Of course, the President continues to assert his innocence of any criminal wrongdoing. We heard his counsel assert that here before us. The President's defense is based on the claim that he was telling the truth when he said under oath that he had no specific recollection of ever being alone with Ms. Lewinsky. It hinges on the claim that he was telling the truth when he said under oath that he never had an affair, a sexual relationship, or sexual relations with Ms. Lewinsky. All of the facts point to the conclusion that the President was willfully lying when he said these things. We would have to be blind to the facts to reach any other conclusion. No clever lawyer's arguments, no legal gymnastics, no attempts to twist and distort the plain meaning of the English language can change the simple facts that any honest review of the record will reveal. The President's claim that he did not lie in his deposition and before the federal grand jury rests, as his counsel acknowledged yesterday, on the argument that Ms. Lewinsky had sex with him, but he did not have sex with her. The simple statement of this argument exposes its absurdity. The President of the United States has been reduced to making such arguments. Governor Weld, one of the witnesses called to testify before this committee by the President's lawyers, testified he assumed perjury had been committed by Mr. Clinton. Mr. Ruff, the White House counsel, himself admitted that the President, in his acknowledged efforts to mislead, intentionally walked up to the line of lying, and that reasonable people could conclude that he, in fact, crossed that line. I candidly submit that a reasonable person is driven by all the facts and circumstances to conclude that the President most certainly lied, and that he did so repeatedly when he was under oath. A reasonable person is also driven to conclude that the President engaged in other corrupt acts to obstruct the administration of justice. The evidence is clear and convincing. It requires a willful suspension of rational judgment to conclude otherwise. Henry Adams, the grandson of John Quincy Adams, said that practical politics consist in ignoring the facts. I don't think there's much doubt in this room that the practical political thing to do in this matter would be to ignore the facts and drop these proceedings. All our lives would be more comfortable if we had never started this impeachment inquiry. All our lives would be more comfortable if we simply ignored the facts, folded our tents, and went home. That would be the politically practical thing to do. But there are moments when constitutional duty collides with practical politics. We on this committee, through no choice of our own, have come to such a moment. We cannot ignore the facts. The oath that we have taken to protect and defend the Constitution requires that we acknowledge the facts before us and exercise the momentous power entrusted to us under the Constitution. It is our duty to act against the misconduct of President William Jefferson Clinton within the framework established by the Constitution. The Constitution does not authorize the censure of a president who is guilty of high crimes and misdemeanors. The Constitution provides for the impeachment of a president who has committed high crimes and misdemeanors. Do we have so little faith in our Constitution and the institutions of our government that we will turn aside from the pattern established in our Constitution and devise what we consider a better way to call the president to account for his misdeeds? Do we believe that our own wisdom exceeds the wisdom of the framers of the Constitution? If I could have 30 seconds, Mr. Chairman. The answer is clear. We must say no. William Jefferson Clinton must be called to account as the Constitution provides. He must be impeached and called before the Senate to answer for the harm he has done. He must be called before the Senate to answer for the harm he has caused by undermining the integrity of the high office entrusted to him by the people of the United States. Thank you, Mr. Chairman.